Mr. Trump, may I have you turn your audio and video on, please?
Hello.
Good morning, and please be seated. Welcome to the 6th District Court of Appeal for oral argument. We have 4 matters on calendar this morning. Matters 2 and 3 will be heard together. Quite a number of the attorneys or parties in these matters are appearing remotely. For those who are here in the audience, I want to let you know that although you won't be able to see those persons, you can hear them. And I'm assuming Mr. Look is here. When you're participating, you'll be able to see on the screen up here at the council table.
Thank you,
You're welcome. So give us just a minute. We have the opportunity to use our laptops. If you see us looking off to the right or left, it's because we have the briefs, the record, our own notes, and so forth available to us here. Give me just a minute to get set up. Court will call matter number 1 on calendar, which is H 049992, the People XREL IAFF Local 1319 AFL CEO Plaintiff and Appellant versus the City of Palo Alto. We also have amicus curiae here today. Let me start with Appellant's counsel. If you could state your appearance and confirm your time estimate, please.
Good morning, Your Honor. Kathleen Mistagny Storm, appearing on behalf of Appellant Relator, and 10 minutes for argument and 5 minutes for rebuttal, please.
All right, thank you very much. Appearing for the City of Palo Alto.
Thank you. Good morning, Your Honor. Eric Della Santa on behalf of Respondent, City of Palo Alto.
And your time estimate is 25 minutes, is that correct?
That's correct, Your Honor.
All right, and then appearing for amicus this morning.
Good morning, Your Honor. Daniel Trump for the Public Employment Relations Board, 10 minutes.
All right, thank you. So Just to be clear about the order in which we are conducting the proceedings, as I understand it, Ms. Storm will proceed with her 10 minutes to be followed by Mr. Trump for 10 minutes. We'll then hear from Mr. Della Santa for the 25 minutes and complete with Ms. Storm finally for 5. Is everybody in agreement?
Yes, Your
Yes,
Honor.
Your Honor.
Yes, Your
Thank you.
Honor.
The court had issued an order, and I think actually you had your own meet and confer on the issue, but I wanted to make certain we were all clear. Thank you very much. So let's then start with Appellant's counsel. Ms. Storm, we're eager to hear your comments on this interesting case.
Thank you, Your Honor. May it please the court. Thank you for your time today. The central issue on appeal is whether quo warranto is a legal remedy and mandates exclusion. This matter has been thoroughly briefed, but I would like to address 3 main issues raised with the statement of decision and judgment and answer any questions the court may have.
Ms. Storm?
Yes, Your
Good
Honor.
morning. This is Justice Wilson. I typically like to allow counsel to get warmed up and before I jump into questions, but I know we have limited time. So I have a few that I'd like to present to you. The first is a little bit of housekeeping. It looks like when the Attorney General granted Local 1319 leave to sue, it stated that approval must be obtained before plaintiff may file a notice of appeal. Is there any evidence in the record that such approval was provided by the Attorney General, and frankly, does it matter?
Your Honor, I'm uncertain if there's documentation of the approval from the Attorney General's office, but approval was granted. Mark Nolan is the Deputy Attorney General that's been assigned to this case. Previously, it was Lawrence McDaniels, and he's been, and I believe he's actually viewing remotely today, monitoring and authorizing each of the actions taken on this matter.
Okay. And so my follow-up question for you was, or is, now you indicate in your reply brief on page 16 that holding and exercising a franchise is frankly a distinction without a difference related to invalidation under Section 809. But my question is, let's say we remove the scenario, or I want to be careful with hypotheticals because it doesn't always overlap. But we have to be mindful that any decision as it relates to Section 809 is going to apply far beyond this case. Let's say instead of Measure D, we assume another scenario where City Council approves a housing measure. And for some reason, they also misinterpreted a statute or provision of statewide importance and value. 2 years into the project, housing is built, roads are being created, purchases are being made. A similar quo warranto action is brought. There's agreement that the City Council unlawfully exercised a lawfully held franchise. Does that mean that the court must invalidate the entire project under your interpretation of Section 809?
Yes, Your Honor. Quo warranto is a legal remedy, and there are many cases. I would direct the court to the IFF versus City of Oakland, Polskamp versus Martinez, Bowling 2 judgment that says that quo warranto is a legal remedy and a mechanism to enforce ouster or forfeiture. The entire purpose of the statutory scheme is to remove a measure or a candidate and invalidate their actions if they were taken outside of their authority. I would also like to note that there is no authority cited by either the trial court or respondent that unlawfully exercise has a distinct meaning from holding or usurping.
Well,
And
counsel, it doesn't appear like there have been a lot of cases teed up for this exact particular argument and circumstance where Section 809 has been presented under this context. And so, part of my question is such that when we craft a decision, we need to be mindful of the consequences broadly as well. And so let's say, for example, 809 did apply. It sounds like the city is arguing that 809 doesn't apply, so invalidation doesn't come into play. Let's say 809 does apply, where we have a council member or deputy district attorney who's unlawfully in office. They make hundreds of decisions over the course of 2 years before a quo warranto was presented. They're taken out of office under 809. No one is going to dispute that. Based on what you're indicating, all of their decisions and actions would be required, we would be required to invalidate, or the trial court would be required to invalidate. Is that correct?
Your Honor, in those circumstances, if the de facto doctrine applied, their actions would stand, but they would be excluded from the office. I'd also like to direct the court to the Bowling-Coronto judgment. This has highly analogous facts. There, the city of San Diego ran Measure B, which was a charter amendment to change the city's retirement system for their local employee organizations. It was initially presented as a citizen initiative, but the court did a lengthy analysis determining that Mayor Sanders was actually acting on behalf of the city, and it was strictly a city-sponsored measure, and that he had attempted to tie in with citizen groups to avoid the obligations of the MMBA meet and confer components. And ultimately there, even in the face of a purported citizen initiative, the court ordered invalidation. I think this shows the strength of the MMBA and the Coronto process, that even where a citizen initiative, which is a constitutionally protected and highly defended right, can be invalidated, it makes it even more clear that here, where there is no dispute that it was the city of Palo Alto that failed and refused to meet and consult, that invalidation would be appropriate. Further, 809 is the only remedy available in an action that falls within the scope of 803, which in the statutory scheme, 803 outlines the scope of a Coronto action. I believe when you look at the whole text canon and read the statute in its entirety, and the purpose of the statute, it becomes clear that if the writ is granted and there is a determination that there was an unlawful holding of a franchise or privilege, then invalidation must follow.
Well, counsel, why did the legislature include the words or exercises in Section 803, but omit them from Section 809? Was it just sloppy drafting? And I would also note that, and I don't know that this has been argued or raised, Section 811, which was a statute, I guess, passed in 1937, uses the term exercise or exercises, which arguably evidences that the legislative intent awareness that exercise in that context does not mean the same thing as hold. Can you address those particular points?
Yes, Your Honor. I believe that there's a number of words in Section 803 that are not repeated in Section 809, and it's not legally significant. Section 803 is drafted broadly to encompass a broad range of persons or corporations and a broad range of actions. And once a determination is found under 803, then 809 mandates the remedy. The cases show that the terms exercising, holding, usurping all have an overlapping and interrelated meaning and context. An inspection of the words exercising, usurpation in other cases also show that they generally mean an action taken without authority. I don't believe the legislature intended for Section 803 to be read in a silo. Similarly, not for Section 809 to be read by itself. They're to be read together and to give meaning to the purpose of the action in its entirety, which is exclusion or ouster. I believe
Storm,
803.
which cases are you referring to that explore the meaning of hold or exercise in Section 803?
Your Honor, there's not a case directly on point defining those two terms in context of the statute. Similarly, there's no cases showing that these terms are legally distinguishable, or that the remedy turns on whether there's an unlawful exercise or an unlawful holding. But I would direct the court to Ex Rel. Lacey versus Robles, talks about usurping, intruding into, and unlawfully holding and exercising. They're used all in a string. Similarly, Gertz versus City of San Bruno discusses that the authority of the board being conceded, Coronto is still appropriate to challenge an unlawful exercise.
All right, so there are no cases, you're referring to lots of cases, but in fact, you believe there aren't any that explore the difference between holds or exercises. And I'm not criticizing you for that, I'm just trying to clarify your answer here.
Your Honor, correct. There are not any that look at this attempt at creating a distinction or an exception.
And what about from other jurisdictions? Do you know of any other jurisdictions, any other states, because I know this writ exists in other states, that explore the difference between hold or exercise in this context?
No, Your Honor. Respondents cited a number of cases, but they're distinguishable. They arise out of Oregon and Washington and Michigan, and there the statutory schemes are quite different. Michigan in particular has a different burden of proof. It requires that the plaintiff establish that there's been material fraud or error. Here in California, the burden is on the defendant, so it would be the city, to establish that they were able to that they were lawfully exercising the franchise of a charter amendment. And this has already been determined both by PERB and this court previously that there was a violation in the procedural regularity of the enactment of Measure D, that being the failure to meet and consult. I'd also like to note in terms of how exercising and holding interact and interrelate with each other. One cannot exercise a franchise or privilege that they do not hold, therefore they are tied together.
Do you think they're synonymous, those terms?
I think they're meant to interact with one another. That in Section 803, you would exercise an unlawful franchise, and that would result in the holding of an unlawful holding of a privilege. I'm very sorry.
It's confusing. No, the statute's very confusing. That's why we're all asking you about it. So
yes,
it's okay.
Let me say that one last time, if I may, that the unlawful exercise produces a privilege that is then unlawfully held. And you cannot exercise something that you do not hold. Therefore, they have to be read as companion terms to give meaning to the purpose of the statutory scheme.
And when you say privilege, you mean the word is franchise, but you're translating that as privilege because that's the more contemporary meaning.
The statute uses franchise or privilege, and the cases also, frankly, interchangeably use franchise or privilege. Here, the court determined there was an unlawful exercise of a franchise, and that would be the charter amendment that was done in violation of the MMBA.
So in your theory, the city did both. They unlawfully exercised and held a franchise?
Yes, Your Honor. And they're continuing to hold the unlawful franchise because Measure D remains intact. The court's order permits the parties or purports to permit the parties to engage in good faith consultation and perhaps then invalidate. However, that's not possible without the restoration of the status quo.
Why not? Excuse me, counsel, but why not? I'm not quite certain I understand that argument.
Yes, Your Honor. PERB's order voided the resolution, and it contemplated that the status quo would be restored. And in terms of labor law, in order to engage in the good faith consultation that's required under the statutory scheme, the parties would have to be placed on a level playing field. With Measure D intact and part of the order requiring that the city simply go back to council and reaffirm its intent to repeal, there's no ability to engage in the requisite good faith give and take for negotiations. It actually encourages the city to engage in bargaining on a pro forma basis, check the box that they have met with the unions, and then go back to the council and simply take a council action to reaffirm repeal and then reinstate Measure D.
Excuse me, Justice Wilson, if I could just follow up. Wouldn't that be true, though, even if they had followed the proper procedure? And if the city was not going to engage in good faith and they were simply going to be, to do a meet and confer pro forma, they could do it then, they could do it under the court order. What difference does it make? What am I missing?
Your Honor, that requires speculation on a hypothetical scenario that did not take place. Here, the city engaged in outright refusal to bargain. It would be highly speculative to determine what that outcome would have been, since there was no opportunity for negotiations. Moreover, ultimately, the employer does hold the authority to implement its will, if you will. But there's always a benefit to bargaining. It is the centerpiece of the MMBA. It allows the union to have a voice at the table. It allows the union to vindicate its authority in its membership's eyes. It also upholds the purposes of the MMBA, which is to promote full communications and foster stable employer-employer relations. Being told that, well, we weren't going to change our mind anyway, so it doesn't matter, completely frustrates the MMBA and guts it. Every employer would be encouraged to take that position, and there would be no ability to engage in negotiations.
Right. We're actually out of time, but if you have questions, I'm not going to stop on this case. All right. Thank you. So we'll be coming back to you, Ms. Storm, I'm sure with more questions. No question about that. So let's turn to Mr. Trump. And, sir, we're interested to hear your comments this morning.
Thank you, Your Honor. Good morning, Justices of the Court of Appeal. I'm Daniel Trump, attorney for the Public Employment Relations Board, and the board is grateful for the opportunity to address the court as amicus curiae. Beginning with the City of Seal Beach case, decades of case law established that the legislature's prescription of labor relations procedures circumscribes unilateral action by public agencies, even where those actions are carried out at the ballot box. This court applied the Seal Beach rule in affirming the board in the prior litigation. At this stage, the city cannot dispute that it had no authority to place Measure D on the ballot. And the city never confronts the inconsistency between its position today and the purpose of the MMBA as interpreted in Seal Beach and the Bowling case. In response to PERB, the city relies on 4 cases, and none of those support its argument. 2, Chase and Mapstead, are injunctive relief cases that hold that once the events sought to be enjoined occur, the injunctive relief action is moot. This is irrelevant because quo warranto is only filed once an election occurs.
Mr. Trump, I realize that your brief is focused on a particular issue, but are you prepared to discuss the question of remedy under the statutory scheme here, or is that outside what you're intending to talk about?
No, Your Honor. We believe that that remedy is discussed in the City of Seal Beach case. Seal Beach was a quo warranto action.
Okay, so thank you, and here are the questions. Do you believe that the remedy in this case is purely one of statutory construction? In other words, what the appropriate remedy is?
That is to say, as to the court's questions to Ms. Mastagni about the scope of Section 803 as it relates to Section 809, we actually do not believe that a sweeping rule that would hold that any unlawful exercise under Section 803 mandates exclusion from the franchise according to Section 809. We don't believe that that is necessary in this case.
Okay, and so what is the what is the rule that you think, the legal rule that exists in this area as to remedy?
Yes, we believe that according to the Seal Beach case, that whenever there has been a failure to meet and confer under Section 3505 or Section 3507, meet and consult, that results in a invalidation of a governing board's resolution to place a measure before the voters, that the Superior Court in a quo warranto action should then invalidate the results of the election and therefore invalidate the charter amendments.
Okay, well, so how is that going through Section 803 and 809? It seems like you're kind of skipping. You're going right from the substantive violation to, well, I'm not sure exactly how those engage 803 or 809, your arguments.
Well, let me explain then, Your Honor.
Okay.
So once there, as was done in this case, when there is a final order of the board subject to appeal with the Court of Appeal that results in the invalidation of the governing board's resolution to put something on the ballot, that action is then a nullity. And under Section 803, we concur with the firefighters that that would be an unlawful exercise of the franchise.
Right, and the only way to get a court order is through 803 with the AG, I suppose 811 maybe, but in this case, 803 with the AG's permission, correct?
That's correct, Your Honor.
All right. And then are you limited to the 803, 809 scheme in terms of bringing the writ and then giving the remedy, or you think there's some other authority out there for remedy, crafting a remedy?
Well, we think that the City of Seal Beach case and the Bowling example show what the remedy is. The statutory scheme, I'm referring to the MMBA, not the Code of Civil Procedure, anticipates that an employer may go to the voters to unilaterally change terms and conditions of employment, but should they do so without bargaining, that would be nullified.
Okay, so can I just ask you again, I'm sorry to keep interrupting you, but I know we're short on time. So you believe, given the facts here and the particular violation that the city committed, the only remedy is nullification of the ordinance or the measure?
Yes, Yes,
Okay.
Your Honor.
So there's no room for equitable considerations about, time has passed or will of the voters or any of the other things that the trial court cited. You don't believe those are a proper purview?
On the facts of this case, no. And I think that the Bowling case provides a useful counterexample. The Bowling, as Ms. Mastagni noted, the Bowling case involved what was nominally a citizens initiative. But the mayor of San Diego had essentially used citizen petitioners as straw men in order to push through a pension reform initiative. And the trial court in the Quo Warranto action in San Diego gave no consideration to the interests of the voters or materiality of the violation. But what's interesting about that is the citizens initiative example might be a good place to consider such equitable factors. For example, the defendants in intervention in that case, the citizens who were nominally the sponsors of the ballot initiative, might have argued that notwithstanding the mayor's conduct, they could have passed that same measure anyway. If they had had evidence for that, then it seems appropriate that the court could have considered it. But this is a far easier case where we do not have any citizens groups who sought to force through a removal of interest arbitration. This is not an example of the citizens petitioning the government to do what it was refusing to do. This was purely the action of the Palo Alto City Council. And if the mayor of San Diego had done what the city of Palo Alto City Council did here, it would have been an even easier case. But again, the Bowling example, we think, shows that even where you have potentially significant equitable concerns, the remedy for going to the voters to unilaterally change employee terms and conditions of employment is invalidation of those charter amendments.
Just to confirm, Mr. Trump, I what I'm hearing you say is that while in some circumstances, in your view, it could be appropriate to look at the equities of the situation, that what you're asking this court to do is to constrain ourselves to the facts of this case and basically find that it is the equivalent of the city of Seal Beach.
Yes, Your Honor,
In
that's
other words,
correct.
a narrow, you would want us to, if we were inclined to move in your direction, you would want us to issue a narrow decision that allowed for some possibilities down the road.
Yes, Your Honor. We don't think a more sweeping rule is necessary. What our interest is in preserving the board's ability to enforce the Myers-Milius-Brown Act. And were the trial court's decision to be adopted, that would create substantial problems for enforcement of the MMBA. This would create a massive loophole in the Myers-Milius-Brown Act where a public agency could determine that it wanted to change terms and conditions of employment. This would not be limited to Section 3507 matters, but 3505 matters as well. So wages, hours, terms and conditions of employment. City Council could put to its voters a measure to gut employee wages and benefits and entirely forego bargaining. But if that measure passes by some sufficient margin, and if the city convincingly pleads ignorance of settled law that would disallow its conduct, and if the union is unable to prove years later that it could have convinced the city otherwise, then the amendment would stand. This would frustrate the purposes of the MMBA at least as much as the Bowling example.
I have one more question for you, Mr. Trump. The PERB decision describes the remedy that you're asking for as the quote, traditional remedy in this context. Do you believe that the courts in the 803 context, do they owe any deference to PERB's selection of remedy? Is there any kind of administrative law type framework that we should be applying here?
Well, in the ordinary course of a PERB decision, where the board issues a decision, an aggrieved party takes a writ of extraordinary relief, the courts do defer to PERB's interpretation of the MMBA. Another option here available to this court would be to say that in a quo warranto action, the Superior Court should give deference to PERB's interpretation of the MMBA and the importance of uniform statewide enforcement of the MMBA.
And if we were, again, just for hypothetical purposes, interested in a deference-based rationale, what would be the strongest case in your view for that?
Well, I would again refer to Seal Beach, which is not a PERB case because this predated the board's jurisdiction over the MMBA, but more recently the bowling example. I would like to also note that not every failure to bargain is going to result in a board order that attempts to restore the status quo. There are whole categories of cases known as effects bargaining cases where the board has allowed ordinances or policy changes to remain in place, finding that after the fact bargaining is sufficient. The bargaining is generally over issues of implementation, and but that the overall policy goal is not rescinded. So it's simply that we haven't done that in this case. And so in this case, the board determined, and the Court of Appeal appeared to agree, that that restoration of the status quo was the correct remedy.
I'm not hearing other questions. Mr. Trump, thank you very much for your comments. Let's turn to Mr. Della Santa and hear from the city.
Thank you, Your Honors, and good morning. Due to obviously the time constraints, I'm just going to dive right into, to begin with, the most important issue, and that's whether Code of Civil Procedure Section 809 requires the court to invalidate Measure D. Obviously, as the parties have all discussed, this is a novel question on which there's no direct California precedent. But though there's no direct California case law, there are substantial reasons to find that Code of Civil Procedure Section 809 does not mandate a validation. And the first is obviously the textual reading. As Your Honors have noted, the word exercise is omitted by Section 809, but not 803. And that omission is legally important language that can't be overlooked.
Mr. Della Santa, did the city make this argument before the trial court?
The city argued that the trial court was not required to invalidate Measure D. However, no, to be frank, Your Honor, the first time that the argument of the word exercise appearing in 803, but not 809, I believe was actually brought up on either oral argument in front of the judge or on her tentative ruling.
Okay, thank you. Keep going. Thank you, sir.
Thank you, Your Honor. But we do agree with the Superior Court's opinion on this, as some of the rationales for why this omission may occur in Section 809, it does make logical sense. So Code of Civil Procedure Section 809 was not written to be the sole remedy provision covering all outcomes in a quo warranto action. So, for example, Code of Civil Procedure Section 806 covers actions where the plaintiff successfully shows they're entitled to an office. And it provides that the plaintiff may hold that office. So similarly, Section 809 only prescribes a specific remedy for the specific situations it covers, which is namely a defendant who is found guilty of usurping or unlawfully holding an office, franchise, or privilege. And if it did cover exercising a privilege that's lawfully held, then the prescribed remedy would make, frankly, no sense. A technical failure in the proper exercise of a legislative power should not exclude the legislative body from promulgating any further legislation, but that's essentially what the statute would require. Because note that Section 809 doesn't simply say that an unlawful exercise of a franchise would void that exercise. It states that the defendant must be excluded from the franchise, and that would not be the correct remedy. And you can take another type of example in a maybe more common situation. So a type of franchise that maybe is less legislative in nature is the franchisor right to collect bridge tolls granted to a private company. And this is a case that was actually discussed in a case that was cited in our brief, which is Truckee and Tahoe Turnpike Road Company versus Campbell. And that case didn't, it only got to I think the fact that this franchise is something that has to be addressed in Quo Ronto. I don't believe there's any published opinion on what happened after that. But basically it was regarding a company that failed to abide, that was granted the right to collect bridge tolls. And so say, for example, you have this company that fails to abide by the terms of its contract, by which that right's granted. That doesn't necessarily mean that it should automatically have its right to collect tolls completely revoked. But that would be an exercise of a franchise that's otherwise lawfully held. Now, take, for example, another situation where you have a company who's collecting bridge tolls where it was never given the right to do that in the first place. Then that's unlawfully holding a franchise as opposed to simply unlawfully exercising a franchise. And in that case, it should be excluded from the franchise altogether. If you weren't granted the right to collect bridge tolls, you shouldn't have the right to collect bridge tolls. But
Sir,
in the case of
yeah, if we believe that 809 applies, then do we have to reverse?
if you believe that 809 applies and that this is a case where exclusion is mandated, then yes, I do believe you would have to reverse.
Right. So your argument hinges on the fact that 809 does not apply.
That's correct.
Okay. Thank you.
And it's essentially based, if I understand correctly, I don't want to put words in your mouth, push back, please, but on the inclusion or exclusion of the word exercise.
That's correct. If the word exercise was included here, then 809 by its text would mandate exclusion, which would mandate invalidation of Measure D.
And what's the difference in 803 between holding and exercising?
So as I was mentioning with the example of, say, a company that's been granted the right to collect bridge tolls, if they when they are granted the actual legal right to collect those bridge tolls, then they are holding that right. If they do so, then they're exercising it. If they do so improperly or out of terms with their contract that granted them the right, then they're exercising it unlawfully, even though it's held lawfully. If they are trying to collect bridge tolls when they were never given the right to collect bridge tolls in the first place, then they are not even holding the franchise lawfully.
And what's the difference in this context between those two words?
So in this context, the city of Palo Alto lawfully holds the franchise to pass resolutions that place measures on the ballot. And I don't think there's any question about that. If they had complied with the MMBA, then there wouldn't be a case in front of this court. The city of Palo Alto has that privilege as a charter city. The issue is not that it was unlawfully holding that franchise. The issue is that it unlawfully exercised that franchise in the sense that it was also required to comply with the MMBA's meet and consult requirements under 3507. And obviously it was found to have failed to comply with those requirements.
But why are you defining the holding and exercising so broadly in the outset? Why isn't it more specifically, do they have the right to hold the franchise with respect to this particular piece of legislation? What helps us understand what the right question is in terms of exercising the right or holding the right?
So I think that maybe goes to the question of just what is the franchisor right that we're talking about here. And it's my understanding that the franchisor right that we're talking about is the right to pass a resolution that places a measure on the ballot to amend the charter. And that you can find support for that by basically going to the equitable origins of the writ of quo warranto, as I believe was discussed in a Oregon case that we cited. You know, it's obviously a very ancient writ, and it goes back to even Old England times. Basically, this notion that all rights or legal privileges come from the king directly. Now, in our case, obviously, we don't have a king, but we do have a constitution. And so you have to trace back rights to that.
But right, so I agree with you there, but isn't the issue they didn't have the right to do it because they failed to meet and consult?
Well, that would say that they unlawfully exercised their right, but not that they don't still have a right to pass resolutions to place measures on the ballot. They just didn't do it the correct way this time. So, for example, you could also say in the case of a referendum, citizens have the right to place a petition to place initiatives on the ballot, and they might do it incorrectly by, for example, say getting the wrong signatures or the wrong addresses put on those on their petitions. But that doesn't mean they don't have the right to put initiative on the ballot. It just means they didn't do it the right way. And that's the difference between unlawfully having a right versus unlawfully exercising a right.
Well, Counsel, as this clearly appears to be an issue of statutory interpretation, why would the legislature make that distinction between 803 and 809? If you can possibly articulate why such a distinction makes sense for our purposes.
Thank you. I would love to. So as I've mentioned, there are other contexts outside of a simple legislative power where these sections would apply. And one is, again, for example, the right to collect bridge tolls. So if you have a company that is that does not have a right to collect bridge tolls at all, but is doing so anyway, then 809 would apply because that's unlawfully holding the power. And in that case, they should properly be excluded regardless of any other considerations. If you weren't given the right to collect bridge tolls, don't collect bridge tolls. But if that company was actually given the right to collect bridge tolls, but simply failed to comply with their terms of their contract in doing so, then that doesn't necessarily mean they should be excluded as a simple matter of course. Perhaps in that situation, equitable considerations would apply. For example, what's the nature of the breach of contract? Was it done in good or bad faith? Was it a one-time basis or a continuing basis? So these are considerations that a court should be able to make in these other contexts. Other examples of
Counsel, why would the legislature mandate exclusion as the remedy for all violations other than the unlawful exercise of a franchise?
In the other situations that 809 covers, which is, for example, usurpation of an office or, again, unlawfully holding a franchise, this is a little bit of speculation on my part because we're talking about a legislature that enacted this back in the 1800s. But it seems to me that I can't imagine other situations where you have someone who usurped an office or is basically trying to exercise a legal right or privilege that they have no right to, where a court would want to give them any resolution other than simply, you don't have a right to do this. And so it does make sense from that point of view that if you have a usurpation of an office or unlawfully holding a franchise, that there should be a mandatory remedy there and it should be exclusion. But in the simple case of unlawfully exercising a franchise, then you shouldn't necessarily mandate exclusion. And so, as another example, and I don't have any cases to cite on this point, although I know I've reviewed them in researching this issue. One of the areas where quo warranto might apply is the franchise of a corporation. So if a corporation is incorporated in California, they have to have a corporate purpose. If they exceed that corporate purpose, then they are trying to basically exercise or hold a right that they don't have. And so in those cases, you wouldn't necessarily want them to have to forfeit their corporate articles altogether, simply enjoin them from continuing to do the action that was unlawful or give them a chance to amend their corporate charter. And so there are these other situations that are a lot more nuanced, where you don't necessarily want to have that one size fits all remedy for a unlawful exercise of a franchise. But it does make a lot more sense to have a one size fits all remedy of simply mandatory exclusion, where you have someone usurping or unlawfully holding that franchise in the first place.
Well, and counsel, if we were to find that Section 809 applies, it would appear that we would also have to address what be exercised from the office, franchise, or privilege actually means. Would you agree?
I would agree.
Okay. And at this point, do you have any definition that might explain why 809 may or may not apply in this circumstance?
Well, the definition that I would offer in that circumstance is 809 obviously doesn't include the word exercise. The words it does include are unlawfully holding an office, franchise, or privilege, or usurping or intruding into. And I would posit that usurping or intruding into, in the context of an office, for example, is a person who claims to or holds himself out as properly holding that office, where they may not actually do so. So, for example, where there may be a disagreement on the propriety of an election. If someone is unlawfully holding or usurping or intruding into a franchise or privilege, then that would be someone who holds himself out as being able to have certain franchises or privileges or have certain rights that they don't actually have. And so that might be, for example, someone who is claiming to be mayor or have the ability to pass laws if they don't actually have the ability to do that. I mean, it could be kind of a silly case. You just have a crazy person sitting on the street corner who claims to be able to create laws. If they don't actually hold the office that allows them to do so, then they don't have that right. And so that's that would be cases of usurping or unlawfully intruding into or holding a office, franchise, or privilege. Whereas exercising a franchise or privilege that is otherwise lawfully held is where you do actually have someone who correctly holds the franchise or privilege. In this case, the city of Palo Alto correctly and lawfully held the franchise or privilege of being able to pass resolutions to place a measure on the ballot to amend their charter. They simply did not comply with their, or was found to have not complied with their procedural requirements for doing so.
Did you have other points that you wanted to make, Mr. De Los Santos? And we've been occupying a lot of your space here, but we're happy to hear other comments that you have.
Thank you, Your Honor. I would also posit that if 809 does not apply, then there is a arguably more generally applicable remedy statute in the Quo Warranto framework, and that is 805. Which states that in every such action, judgment may be rendered upon the right of the defendant and also upon the right of the party so alleged to be entitled, or only upon the right of the defendant as justice may require. And those words, as justice may require, do appear to authorize an equitable remedy as the one that we've argued for in this situation. Now, I know that there are a lot of other issues that have been brought up on briefing. I don't believe other issues other than simply the nature of the Quo Warranto statute and perhaps deference to PERB have been discussed this morning. So I can turn to the deference to PERB issue now, if that pleases the court.
Yes, I think that would be helpful. Thank you.
All right. Thank you, Your Honor. So both Local 1319 and PERB have basically argued that the Superior Court failed to uphold PERB's standard remedy, which is restoring the status quo. As kind of a threshold matter, I noted that neither party really gave a basis for what relevance that has to this Quo Warranto case. So again, this is not the case that was before PERB in the first place. This is not the case regarding whether or not the MMBA violation occurred. That's already been decided. This case is about, given that it's been decided that an MMBA violation occurred, now what should be done about Measure D? And in those Quo Warranto, in a Quo Warranto case like this one, PERB does not have jurisdiction to decide this issue at all, and it involves issues that are far beyond simply the MMBA. The only way, in the city's opinion, to get to the issue of whether or not deference should even be accorded to PERB in the first place, and if so, how much deference, is if you even get to the question of whether the Superior Court had authority under the Quo Warranto statutes to do anything other than simply invalidate Measure D. And so that, in other words, you have to already decide that Section 809 doesn't apply. And if you've decided that Section 809 doesn't apply, then you essentially have the court's remedy being determined under an abuse of discretion standard. And neither PERB nor Local 1319 have given any argument or legal authority to show why the amount of deference that the court already accorded to PERB was so egregiously insufficient as to become an abuse of discretion.
Mr. De La Santa, I want to ask you about what you just said. In this context, on these facts, don't the 809 remedy and the PERB remedy amount to the same thing?
Well, so if 809 would require invalidation of Measure D, and if PERB states that their own remedy would also be to invalidate Measure D, then yes, the end result might be the same.
And isn't
but
that
how
what we
get-
have here?
Well, how we get there is a very different roadmap.
Okay, but the
depending
answer
on-
is the same, right?
Correct. PERB is arguing that that Measure D should be invalidated.
Okay. So,
But-
right, I understand you're saying that the math is different, but the answer is the same.
That's correct, Your Honor.
Okay. I'm sorry, keep going. Thank you.
All right. Thank you for the clarification. And so the first point I want to make, as far as the deference that the Superior Court accorded to PERB, is that the Superior Court, in our view, actually already did accord quite a bit of deference to PERB. And so, for example, the court took a very measured approach. It is, to be frank, it's not the outcome that we had asked the Superior Court for. We had asked them to essentially deny Local 1319's petition for writ of quo warranto. However, it is, in our opinion, a result that did a admirable job of trying to consider the interests of both parties and reach a fair compromise. And so while the court considered other issues, as it frankly should when considering such a complex issue of whether or not a charter amendment that was overwhelmingly supported by the city electorate should be invalidated, it also considered PERB's chosen remedy. And in fact, as I'm sure your honors have seen by reviewing the initial tentative ruling and then the evolution of the court's order from that tentative ruling to its final statement of decision, the court took pains to try to make sure that it could try to restore the status quo as much as possible without also unnecessarily infringing on the rights of the Palo Alto electorate to essentially the sanctity of their elections. And neither Local 1319 nor PERB has truly given any grounds showing that there is, frankly, any difference between what the Superior Court ordered and actually restoring the status quo. I know they obviously argued that Measure D would be a true restoration of the status quo, but under the MMBA, there's no entitlement to have bargaining changes subsequently ratified by the electorate. The vast majority of MMBA negotiations are over, things like wages, hours. They're not required to be submitted to the electorate afterwards, and most unilateral changes taken by an employer don't affect the charter, and if the PERB voids them, then they go back to the bargaining table and reach a resolution. But the new resolution also doesn't have to be approved by the electorate. So the notion that basically requiring this change to be reapproved by the electorate is a failure to restore the status quo, I don't believe has any evidentiary or legal support. Secondly, I would also point out that the deference that PERB has shown in typical contexts is in regard to its interpretation of the MMBA, which typically comes from appeals from PERB's decisions. And again, that deference was already fully accorded to PERB in the prior appeal on this case. And to the extent that PERB has interpreted the MMBA to conclusively state that there was a violation of it by the city's failure to bargain here, that deference continues to be fully accorded to PERB. Neither the city of Palo Alto nor the Superior Court has made any determination or argument that goes against this notion that an MMBA violation occurred. Again, the case in front of the court here is simply, given that the MMBA violation occurred, now what must be done about Measure D?
Mr. De La Santa, let me ask you this. One of the points that Mr. Trump raised was that, failure to invalidate the measure under 809 would essentially undercut the purpose of the MMBA in a way that would be extremely negative. Can you address that point?
Thank you, Your Honor. I would love to. And maybe as a kind of initial issue here, I know Mr. Trump also heavily referred to the Bowling case and referred to this as kind of a more clear-cut example of where the measure should be invalidated as opposed to Bowling. I would strongly disagree with that and actually find that if Bowling had resulted in allowing the initiative to stay, then that might be more of the kind of blueprint that Mr. Trump is worried about. So the issue and in my opinion, the critical difference there is that in Bowling, even though you had maybe more of a difficult question on whether or not there was initially a violation of the MMBA, because instead of having a mayor act through his official office as a mayor, he essentially, it was found that he acted essentially under the color of his office by using the citizens to pass an initiative instead of going through his office. I think that's where the MMBA violation came from. But the point is, he had this kind of roundabout way of essentially intentionally trying to avoid his meet and confer obligations by using a different path to reach that result. In this case, there is absolutely no indication of that kind of bad faith. You have a charter for the City of Palo Alto, which provides for mandatory interest arbitration for public safety employees. The City of Palo Alto, acting in its official capacity, wanted to consider removing that for frankly very good reasons. They did not try to do any sort of bad faith manner of getting to that removal. They did a simple notice of public comment. They complied with all their requirements to place it on the ballot. There was a simple dispute between the City of Palo Alto and Local 1319 whether they were in fact required to meet and consult with Local 1319 before putting that on the ballot. And while I'm very well aware that precedent has now been set saying that they were required to, at the time before that precedent was set, there was very good faith reasons for them believing that they didn't have to. And I believe the Superior Court noted that this was not them trying to push the boundaries of what they could get away with. They were relying on the opinion of their legal counsel, who was relying on what appeared to be clear per precedent, stating that interest arbitration was not a mandatory subject to bargaining. So there was no element of bad faith here, whereas in Bowling there clearly is. Additionally, I'd like to say that in Bowling 2, when the Court of Appeal basically held that the remedy has to be found in a quo warranto court, it noted that the initiative's continued validity was a novel issue, which did not yet have a clear result. And there's no decision in Bowling 2, contrary to I think assertions that have been made here, that even in that case, it was found that invalidating the initiative was mandatory. In fact, it wasn't. So after Bowling 2, a quo warranto suit was initiated, similar to this one, and I believe a Superior Court decision was reached on that, I believe shortly after the tentative decision was released in this case. And in that Superior Court decision, which was not published, nor is any sort of binding precedent, the Superior Court did find that it would invalidate the initiative, but not that it was forced to under any stretch of the means. It simply found under the facts of that case, including, one, the bad faith actions of the mayor, and two, the fact that I believe the city of San Diego itself did not continue to support the initiative or defend the quo warranto action. Essentially agreed that, yes, please invalidate the initiative. And so under those specific circumstances, the court invalidated the initiative, but also specifically constrained its holding to say it's applicable only to these circumstances. It was not creating any sort of broad line rule that in any case of an MMBA violation, regardless of the nature of it, you must invalidate a charter amendment or initiative that resulted. And so because Bowling has that kind of different context, and because here the court, in our case, actually also made a very constrained, limited holding, saying that basically because of the specific factors at play here, including the good faith actions of the city, and the fact that Local 1319, including in this quo warranto action, introduced no evidence that that supported any argument that the city's failure to bargain was a material one or made any material effect on the ultimate outcome. Under these very specific circumstances, it allowed that basically bargaining could continue. And notably, it still didn't completely allow the city to rely on Measure D as a currently enforceable law, the way the city would have the way the city asked for and would have liked. It still held that Measure D is essentially basically put in abeyance until the bargaining requirements have been completed, and would only stop being in abeyance if a result of good faith bargaining still results in basically Measure D being the ultimate outcome. And so essentially the only difference between the Superior Court's order and the full remedy that PERB and Local 1319 have asked for is that if, as an outcome of bargaining, both parties decide that, yeah, okay, we still want to proceed with removing interest arbitration, then we don't have to go in front of the voters a second time for it. That's essentially the only difference. And again, that's not something that the MMBA would require in the first place.
So I'm going to stop you there for a minute. Justice Wilson, if you have a question, go ahead.
Just a quick, well, we'll see if it's quick. I had asked the counsel for Local 1319 whether it had received leave to sue by the Attorney General's office, and they indicated that they had received approval. Is the city taking a position as with regard to the appealability at this point related to approval by the Attorney General's office?
No, Your Honor, I don't believe we would have the ability to do that simply because the communications between Local 1319 and Attorney General are communications between them. I don't believe we're privy to it. However, that being said, I do recall being informed by Ms. Storm that the Attorney General approved their appeal to go forward.
All right.
Thank you.
All right. Thank you very much, Mr. Della Santa, for your comments. Let's turn back to Ms. Storm.
Thank you.
And I'm assuming you have a lot you want to respond to, so you go ahead.
Yes, Your Honor, thank you. I'd like to pick up in regards to the Bowling-Quaranto judgment, if I may. There we can see that it's not a published decision, and but it would be highly instructive to this court. The decision, it discusses some amount of reticence or constraint, but I believe that the trial court and respondent has misread why that was. Again, we've already discussed this was a citizen initiative, and that right is enshrined in the Constitution, and it is highly defended. Therefore, I believe the Bowling-Quaranto court was saying that they were not going to always agree that a citizen initiative would be invalidated if there were a violation of the MMBA. However, they determined on the facts in the Bowling 1 decision that this was actually not a citizen initiative, but was just the mayor acting in concert with citizens trying to evade his right to bargain. In that court, they did not consider the materiality of the violation whatsoever. They just determined whether or not there was a violation, and in fact found that the MMBA violation is in the citizens initiative itself, and that you cannot, that they're tied together. And they relied on Polskamp versus Martinez, which says that the only remedy to undo a procedurally irregular measure is quo warranto. You cannot separate the violation from the measure and offer some sort of remedy short of invalidation. Additionally, plaintiff or respondents counsel spent a lot of time saying or discussing the alleged deference the trial court gave to PERB, and it is just wholly unsupported by the record. In fact, the trial court disregarded PERB and this court's prior holdings on the matter when it was the city was adjudged to have violated Section 3507. Respondent made a third attempt at the trial court with the same arguments that were rejected out of hand by PERB and out of hand by the 6th District Court of Appeal previously. There was, in fact, no change in law and no good faith misreliance on the law. 6th District Court of Appeal confirmed PERB's decision on a clearly erroneous standard and PERB's findings of facts on a substantial evidence of the record factor standard, and determined that there was a per se violation. That means the outright refusal just on its face violated the MMBA. There's significant authority that says that you do not look at the intent of the offending party or the motive, just stop at whether or not there was a violation. Here, city was represented by sophisticated counsel who was directed a number of times to Section 3507 by Local 1319 and had repeated requests to meet and consult pursuant to that provision. And they just staked their legal argument on the grounds that 3505 applied and not 3507 and refused to bargain, which is a per se violation and absolutely bad faith. Moreover, I would note in the record, there is a city attorney, I believe the last name was Strump, who had in fact advised the city that she believed that the MMBA was implicated by their course or desire to amend the binding interest arbitration procedures, and it noted that there was some liability in failing to do so. The city proceeded at its peril and cannot now benefit from its bad acts by saying this would be too difficult to undo. This will undo the will of the voters. Well, we had good reason for this policy change. Those considerations are wholly irrelevant. I'd also like to note, and I think it's very telling, that the city has failed to cite a single California Quo Warranto case that says exclusion, something other than exclusion, is the appropriate remedy. Rather, they've tried to direct the court to outside authorities, to injunctive relief cases, to writs of mandamus cases, and say, forget that Quo Warranto is a legal remedy and we're obligated to provide exclusion, and look over here, court, look somewhere else. I also would like to note that the case that Mr. De La Santa appeared to be referencing about corporations and not invalidating or excluding a corporation if they've unlawfully held an action is not a California case. He seems to be referring to the Troy case that he cited in his in his opposition. That's a Washington case. And there were two dissenting opinions that said ouster should have been ordered immediately because there was no way that the corporation was acting in compliance with the law and could not get in compliance with the law. There's been a number of misrepresentations to the court in regards to the authority and the factual underpinnings of this case, and they should be noted.
Ms. Storm, if I can stop you. Mr. Trump suggested that this court need not write a definitive exposition of the relationship between 803 and 809, but simply could take the approach that in this case, given this violation, invalidation of the measure would be appropriate. Is that an approach that you would support?
Your Honor, I think that the appellate court's role on a matter of a purely legal question is to provide uniformity in the body of law and guidance to the trial courts and promote finality so that these disputes do not arise again. However, I would leave it to this court's discretion if they determine having a more narrow decision would avoid any future concerns. I'd also like to step back to the statutory language itself. There was a question about Section 811, and then respondent raised an issue with 805. I believe Section 805 does not apply whatsoever in this context. It's looking at whether or not a defendant should be excluded if the situation is appropriate and if the court is also going to affirmatively place the plaintiff in the position. This is not analogous or applicable to this case. Section 811, I do, though, believe is instructive, especially if you look at the whole text canon. In 811, it addresses a local government's ability to bring a quo warranto action under the statute, and it includes the phrases usurps, intrudes into, or unlawfully holds or exercises any franchise. Again, similar to what's found in Sections 803 and 809. I'd also like to note that quo warranto, where it is available, is the exclusive remedy, and I think this court previously understood that to give meaning to PERB's order voiding and effectuate the purposes of the MMBA, the next step and the final step would be for the quo warranto action to be initiated and that Measure D be invalidated. There was the only issue on appeal originally that was remanded back to PERB was whether or not PERB could in fact order a legislative action, as PERB's initial decision had ordered rescission of Measure D. That was found to be in violation of the separation of powers, and so this court had a lengthy discussion in its decision about that PERB could void if on remand it chose to, and that would have the effect of undoing the unlawful act, but to fully effectuate the contemplated remedy of restoration of the status quo, plaintiff would need to seek an action in quo warranto. I believe everybody at the outset understood that invalidation would be the result. And I think that's also shown by the fact that respondent did not initially raise any arguments or plead that exercising an unlawful franchise is somehow different than holding an unlawful franchise or privilege. That was something that the trial court created, frankly, out of whole cloth to excuse itself from the legal remedy of invalidation. I'd also like to note, and it wasn't raised, or we didn't have an opportunity to discuss it, but the court's order, the trial court's order, excuse me, also seems to permit the city and Local 1319 to directly agree to alternative dispute resolution procedures, after which it would invalidate Measure D. This violates the California Constitution, the city's own charter, and the elections code. And most importantly, I think it underscores the situational concern the court raised with the will of the voters. The court was willing to deny meaningful and relief consistent with the law, meaning invalidation, based on the will of the voters. But then if the parties are able to negotiate a difference, the court is happy to then invalidate the measure and overturn the will of the voters. I think this shows that the will of the voters was just a straw concern and should not have been considered. There was also a discussion, and I think it was raised in my initial arguments here about, couldn't this just be the result at the end anyway? And respondent has argued that this, creates a greater cost or process for the city. But our California Supreme Court in Seal Beach has already noted that you should not be looking at the substance of the charter amendments or the policy considerations, but the procedure by which they are enacted, and that compliance with the MMBA is a minimal burden, and that any cost of compliance does not supersede the statewide interest in enforcement of the MMBA. Lastly, barring any questions, I would just like to reiterate that Section 803 does not use the word privilege, and 809 does use the word and does not use the word exercise, but that 809 contemplates that the unlawful exercise has produced an advantage, and that is the unlawful holding of a privilege. When those sections are read together and give meaning to the entire statutory scheme, it is clear that exclusion is mandatory. Therefore, we would ask this court to please direct the trial court to invalidate Measure D and restore Article 5's binding interest arbitration procedures. This will comply with Section 809's required judgment, effectuate PERB's order avoiding the resolution, and uphold the statewide interest in the MMBA.
All right, thank you, Ms. Storm. And thank you to all three counsel for your comments this morning on an interesting case with a very unusual writ. I'll admit I wasn't acquainted with it before, so it's been interesting to learn all about it. At this time, the matter is under submission, and you will receive a written opinion within 90 days of today's date. Thank you for being here with us. At this time, there will be a panel change. Justice Danner and Justice Wilson will depart, and I will be joined by Associate Justices Adrian Grover and Cynthia Lee. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.
Council can step forward on the next case. We're going to need just a minute while everybody gets situated. Thank you. All right, the court will at this time call matters number 2 and 3 on calendar H050802 and H050729. Kenneth Garrard et al., Appellants versus Total Lender Solutions, Inc., and Robert Richardson, Intervenor and Appellant versus Total Lender Solutions. Appellant in each case is represented by counsel who is present here in the courtroom. If you could state your appearance and we'll confirm the time estimate, please.
William B. Look Jr. for the appellants, Your Honor, and I need about 10 minutes to present my basic points, and then I'll reserve 5 for rebuttal.
All right, and then appearing remotely for Total Lender Solutions, respondent in this matter, counsel, if you'll state your appearance.
Good morning, Zachary Shore.
And confirming 15 minutes for you, sir.
Yeah, that should be more than enough.
All right, thank you very much. Mr. Look, you may proceed. Thank you.
All right, Your Honor. The reason I asked for oral argument is that in my brief at page 59 and 77, 78, I broach an issue but don't tie it together. And that issue is the whether or not the decree of distribution in the underlying probate case, Monterey Probate 17109, which is still pending, is a void decree. And the essential issue there is that because jurisdiction is in rem in probate, the issue is that the court cannot distribute more rem than exists. And in the decree, if you do the math, there's $119,000 of prospective value that's purported to be distributed. That is the future value of the rem. So you have a case that is rem plus FV, or future value. But future value is not something that is within the court's jurisdiction, and was not in the court's jurisdiction in December of 2006 when the decree was rendered. What the plan of the estate was, apparently, and the best recourse for the court in assessing this issue is to review the consents provided by the heirs who received a share in the $180,000 promissory note and $45,000 shares that compose a liability that was added to a pre-existing liability, burdening the decedent's residence, which is the only asset in the estate. That was valued at $326,000. There was a $265,000 lien, and then a $180,000 lien created by the judgment. So in essence, the 4 of the 5 surviving children who were represented in 2 cases by their descendants, but it was 5 intestate shares essentially. 1 went to Mrs. Gerard. The other 5 received the $180,000 lien. The problem is that when you add up 265 and 180, you get $445,000, an amount $119,000 in excess of the stated value of the estate of $326,000. So the issue is very simple, that despite the estate plan, the court lacked the jurisdiction to execute it because it exceeded the value of the rem. And as a probate court, the only jurisdiction the court had was the rem. If you review the consents, which are at the court transcript, that's the court transcript under this case number, not the one that was taken notice of from the last appeal.
Mr. Look, I'm going to interrupt you for just a minute.
All right.
So let's just assume for the moment, that the court did exceed its in rem jurisdiction. What is your authority for the notion that the order then became void as opposed to voidable? Doesn't caseload say that so long as the Superior Court has fundamental subject matter jurisdiction, and the probate court is a division of the Superior Court, it is the Superior Court sitting in the probate division, essentially, that even if there were to be some action taken in excess of in rem jurisdiction, that then the order would be voidable as opposed to void?
Well, the answer to that is first of all, that the concept of a probate is that there is a rem on the date of death. All of the intestate heirs have an interest in that rem dating from the date of death because the succession is regarded as a fictitious succession, but an at-law succession to an interest in the rem on the date of death. So the date of death in this case establishes what assets are in the estate. And in this particular estate, aside from some minor value in household goods and effects, was the decedent's residence. and that represents the lion's share of the $326,000 that was found in December. The probate started in 2004, but by December 2006, that was the value the trial court assigned to the rem. So that was the scope of her jurisdiction to distribute anything.
All right, but there's in rem jurisdiction, and then there's fundamental
I understand.
subject matter jurisdiction. And so my question is, what you're describing is an action that, from your perspective, was taken in violation of in rem jurisdiction on the part of the court. But wouldn't that render the order voidable as opposed to void?
Well, let me address that. There is authority that addresses that very issue. That's the estate of Kampen, Kampen. It's 211 Calap 4, 971. And it's a long opinion, so page 1003 contains the most relevant language. A substantial part of this opinion deals with an attempt to sanction the administrator, so there's a lot of reading before you get to what's relevant to our dispute. In that case, there was one administrator but two estates. At issue were assets that were included in estate number one that consisted of a pair of retirement accounts, which contained a beneficiary, a designated beneficiary that was an opera association. The decision of the court was that because those retirement accounts had been included in estate number one by mistake, and the court had exceeded its jurisdiction by purporting to issue a decree that affected those two assets, that decree was void because it exceeded the in rem jurisdiction of the court. What the court's order was, the remedy in this case, was to void the decree in estate number one, and to order that matter to be redetermined by on remand by the appropriate probate department. In the second case, it was also remanded to the probate court, but this time for the exercise of its continuing jurisdiction to deal with what it was treating as newly discovered assets that weren't part of the original distribution in estate number two. And the other authority is in the Ross and Cohen handbook, a probate handbook, a Rudder outline. And it's discussed, for the record, I'll give you the paragraph and page numbers. It's 16.2, in volume 2, it's section 16.428.10, subpart B, on pages 16.127 and 16.128 in the outlines pagination.
And is this a new authority that you hadn't included in your briefing?
No, well, I cited to Ross and Cohen, but what I did was, State of Kampen is cited in my brief, but I went and tried to update Kampen looking for this very issue, not a tangible asset, in this case financial, but still that's a financial asset, to see if there was any decision that dealt with this problem of future value or appreciation value that the court assumes exists at the time of the decree of distribution. Because you cannot add up the liens against the real property that Mrs. Gerard received and stay within the value of the property. So as I pointed out in the brief, and I point out again here, that meant that Mrs. Gerard was giving a prescription for failure. Because on the eve of the great foreclosure crisis, in December of 2006, the court distributed a parcel of property that was underwater on the date she received it. And so, not surprisingly, in 2007, she defaulted and was unable to refinance or sell. And so the ensuing foreclosures that took place in this case were a precise result of that, of the court distributing and I point out to the court that my clients are a poor family. They're not sophisticated. At this time, Mrs. Gerard was disabled. Mr. Richardson became disabled while this case was pending as a result of an accident in 2019. And her work experience was as a sales clerk. So I don't think any of them really understood the nature of what the trial court was doing. And again, I asked the court to review the consents. They're at the clerk's transcript at page 77 versus 88. In which it's basically outlined that the court is engaging in the kind of speculation that created the great financial bubble that collapsed and resulted in the great foreclosure crisis, the millions of foreclosures as real estate values collapsed when the secondary financial market in collateralized real property debt instruments, those business trusts.
So in your view,
came into being.
what should the probate court have done, recognizing that?
Well, I think that the probate court was kind of limited, in my view, because of the doctrine that the rights adhere in the property.
Right. I know that you believe the probate court was limited in its powers, but specifically as a practical matter, the probate court has this case in front of it and this estate, and what should it have done?
Well, I think she should have. What I think should have happened is the title to the house should have simply been distributed to the heirs and as tenants in common, and not gotten involved in this speculative business of taking a loan as an administrative cost to improve the house that also paid several administrative expenses, including a pair of legacies and the attorney's fees and the administrator's fees and other costs of the administration against the title, and then distribute the title with speculative value. That's the problem. That when you look at this, and particularly if you review the consents, what the court was engaging in is real property speculation, because it was being distributed on the assumption that the value would rise. And Mrs. Gerard would be able to transact business as this, who was not a sophisticated person, believe me, was going to be able to transact a realization of that FV, the future value in the equation, REM plus FV. And what I'm saying is the court does not have jurisdiction, probate court does not have jurisdiction to do that. You can't distribute something that does not yet exist.
All right, I'm going to stop you there because I think we do understand the argument. We'll come back to you for rebuttal, Mr. Shore.
Thank you, Your Honor.
You're welcome.
Good morning, may it please the court. My name is Zachary Shore. I'm obviously here on behalf of respondents Podluski, Reed, Newman, and Total Lender Solutions. You know, I had come prepared to discuss what was briefed. This is an entirely new argument. It sounds like Mr. Look is making a collateral attack on the 2006 probate judgment based on his speculation that the probate court did not accurately consider the fair market value of the property back in 2006. I think that ship has sailed. We're in 2024. It's been about 18 years. With respect to his reference to the estate of Campen, which he did cite in his brief, and I read, the estate of Campen did deal with a unique situation where the probate court arguably didn't have jurisdiction over an asset that it was trying to marshal. The asset was in a different estate at the time. And so that portion of the award that dealt with, or the lower court ruling that dealt with the asset that was not a part of the estate, was properly set aside. This is not that situation. I don't think anyone is here disputing that at the time of the 2006 probate in the MP 17109, that the Laguna property was not a part of the estate of Alice Richardson. It was a part of the estate. There were hearings, and it was distributed. And so I think that, at least in my mind, disposes of the arguments that Mr. Look has raised for the first time in oral argument. And I think it's a bit ironic that he comes to this court saying, on the one hand, the probate court had limited powers to deal with this property. But then on the other hand, in all of his briefing, he's saying the probate court is the sole jurisdictional place to deal with the 4 lawsuits that ensued, or I guess, the 4 lawsuits that ensued following the probate. So that's what we're here to talk about. And I think I just want to make a few quick points, and then I'll have said my piece. One main point is that this is the 4th action in this. Case number 1 was filed by the Gerards as a civil action. Case number 2 was also filed by the Gerards. Case number 2 being the 2013 tax lien case filed by the Gerards as a civil action. It was settled. Case number 3 is really a follow-up to case number 2. It's enforcing case number 2, also a civil action. That one was filed by my clients. Case number 4 is again civil action filed by Mr. Look himself on behalf of the Gerards, and that's what we're here on. So the idea that he could file, or that the Gerards or the Richardsons could file 3 different actions seeking the power of the fundamental jurisdictional power, I believe, of the civil court to deal with this, and then years later decide to do it a collateral attack. I think it's a reach. A couple last points. And I've sort of touched on the first one in response to Mr. Look's novel argument today. The probate case was closed. It was closed back in December 2006. So that relates to any argument that he has about whatever happened back then. But it also relates to, this is a post probate, a closing of the probate estate dispute. And I think that the case cited, I think Mr. Look cited it, and I believe it was cited in my papers, but it's a recent case. It's a 2020 case. The case of Capra versus Capra is probably the closest case to this case, where there was a distribution back in, I believe it was 1993 in that case. And then after decades following the distribution, a dispute arose concerning the management and ownership of a cabin that was distributed in June Lake as a part of the original probate. And the Court of Appeal in the 3rd District went through a good analysis, I believe, a thorough analysis of why the Superior Court in Mono County had the ability to deal with it on a fundamental basis. My last and final short point will be simply that I represent some lenders. The lenders came into and essentially lent money to the estate of Alice Richardson. They did that just like any other lender lends money. They got a deed of trust, and they didn't agree to have their rights limited by the deed of trust. They didn't agree to give up the right to foreclosure or to the power of sale in the deed of trust. Likewise, they didn't agree that they were going to be subject to future probate actions. If they did agree to that, you could think of this from a broad policy perspective. Nobody's ever going to lend money in a similar manner to a probate estate if that means that in order to deal with a default on the loan, they have to go back to the probate court. The same could be said about a probate sale. No one's going to buy property out of probate sales because if they're going to have to continue to litigate any issue that arises in the probate court. Probate approved the transaction back in 2006, and this is a post-probate dispute that is properly, as Mr. Look and his clients have acknowledged on at least 3 prior occasions, in the civil court. With that, I submit, unless there's any questions.
My only question is whether you're a movie fan and if you recognize the name in the Capra case, Frank Capra. It happened one night. He was a very famous director, but predates probably most people in the courtroom, I'm going to guess.
I recognize the name, but I can't say that I've seen a movie but it definitely is a famous name.
Right, worth watching. So thank you very much, Mr. Shore. Mr. Look,
Yes, Your Honor.
we're interested in your comments. I have a couple of questions for you, actually based on the Frank Capra case. But this really does appear to this court, to at least to me, to be a post-probate dispute, which is, I think, a lot of the point that Mr. Shore is making in terms of the jurisdictional arguments that you're raising, and what's your response to that? It's a post-probate dispute. There's no longer a rem before the probate court.
Well, there is, this is remanded.
The probate estate was closed.
No, well, he says it's closed, but if you look at the file, and I had the clerk's office copy the file, it is not closed. It's still open because and he ignores the issue of ongoing jurisdiction. You can reopen an estate. Let me point out that on the jurisdictional issue, when they decided to do business with the probate court and to loan money against an asset of the probate court in order to pay administrative expenses, they submitted to the jurisdiction of the court with regard to the debt. This is not a private sale in a subdivision.
Indefinitely?
I would say, let me address that issue, because first of all, this is not the first time I've raised the issue. As I said, it's raised at page 59 and 77, 78 in my brief. I just didn't tie it off, which is why I made it the subject of oral argument today, was to make it clear, because it dovetails into my request for a relief, which I'll address in just a minute. But there's plenty of authority that says a probate decree, like any other judgment or order that amounts to a judgment, can be revisited if it's void on its face. And the authority for that, the two cases I'm going to...
That's circular, because it would have to be void on its face if the court doesn't have jurisdiction. I think more, Mr. Look, I think more to the point would be helpful to the court if you addressed Capra.
Oh, Capra is very simple. Capra is a case that depends upon in personam jurisdiction over the trustee, not jurisdiction over a probate estate. The trust in issue in that case had been distributed out of the probate case in Los Angeles, and the real property itself, although it was on federal land, was within the jurisdiction of the Inyo Superior Court to decide the trust issue that arose. So what the court did in Capra, by the way, was remand it to the court in Inyo to make a determination of whether it should exercise its in personam jurisdiction over the trustee or transfer it back on the Inyo Court's initiative to Los Angeles back to the probate court. And the court makes a specific statement, as I cited in my brief, that this does not involve any issues relating to the administration of the probate estate. This is not a probate case. The disputes here are between the beneficiaries of the trust and the trustee over a piece of land that was in Inyo County. So the distinctions here are very important because, if I may, there is a rem in a probate case, but a res in a trust case. The assets that are conveyed to a trustee in trust, subject to the terms of the trust, are the res, but the trust itself is not considered an entity in the same way that a probate is, in a sense, a special type of lawsuit. So it is something that exists, and it exists as a consequence of the doctrine for probate court that the court's jurisdiction is over the rem, and its job in administering the estate is to see to it that it's distributed to the correct heirs. That's
I'm not understanding the distinction that you're making here, including the Latin conjugation, which I'm going to challenge you on, because we're talking about in rem jurisdiction, but it is jurisdiction over the res, which is the estate.
Yes, it's
and so how are you distinguishing between a res that is in trust versus a res that is part of an estate?
Well, that's because the jurisdiction in a trust case is in rem over the trustee. And the court's job is to enforce a pre-existing paradigm for transacting business between the beneficiaries and the trustee involving the trust assets. That's the trust and the instructions in the trust for how to administer the trust.
But in rem jurisdiction is always jurisdiction as to a thing or a particular circumstance.
Well,
so how can you say there is in rem jurisdiction over a trustee?
I beg your pardon?
How can you say there is in rem jurisdiction over a trustee? In
didn't
rem
say that.
jurisdiction, oh, well, then I misunderstood your
No.
comment.
I'm not saying that there's in rem jurisdiction in a trust case at all. the court has jurisdiction through the trustee to make determinations about what is done with the res, in the sense of making sure what's done with the res comports with the prescriptions in the trust instrument itself. But the jurisdiction is treated as over the trustee. So, for example, we could have a trustee who lives in Oakland in Alameda County and have jurisdiction proper there, even though all the assets of the trust are here in Santa Clara County. And that's because the court would be issuing orders to the trustee to carry out some action consistent with the trust instrument involving the assets, a res here in Santa Clara County. But the jurisdiction is exercised against the trustee. That's why I made the point that the jurisdiction of a trustee more resembles quasi-in rem jurisdiction that affects a rem, but is jurisdiction exercised based on in personam jurisdiction over a trustee. The same distinction applies here, that a probate court is exercising jurisdiction over the rem. The basis of jurisdiction is the rem, some of which is supposed to be situate in the county that takes on the jurisdiction of a probate. That's why I've spent so much time in the brief discussing this issue of how does the court acquire in rem jurisdiction in probate. And it's a specified procedure you have to follow, but once the decree, the petition is published, and the judge appoints an administrator or an executive, in other words, a representative for the court for purposes of administration, that's it. That locks in the jurisdiction of that court in rem over the probate. And there are actually cases out there, now these are older law, but there are cases out there where a judge has obtained jurisdiction, and it turns out later that there are no assets actually in that particular county, even though it was the county of residence, or mistakenly. The court receives the petition that mistakenly alleges that there are assets in the county and the decedent died in the county, whereas it turns out afterwards that they're not actually in that county, but the court still has jurisdiction because of the findings of jurisdictional facts that become non-appealable within 60 days after the publication and the appointment of the state representative.
So that is jurisdiction to do certain things, but you would have that turned on its head and limit the probate court's jurisdiction.
All I'm saying is the probate court's jurisdiction, what the Campen case stands for is the proposition that the court's jurisdiction in probate only extends to the rem. It does not extend to assets that are not properly part of the estate. And the point I'm making here is, in challenging the decree and alleging that it is void, is because of that very reason, that the court purports to distribute $445,000 of value in an estate with a total value of $326,000, which means that there's $119,000 being distributed, mainly in the form of the promissory notes that the Richardson siblings received, that simply did not exist. I don't see how a court can equalize a distribution using my expression, the FV, res plus FV, future value. You're not equalizing anything. You're just in a sense, assigning future value that doesn't exist yet to some of the heirs, to the detriment of other heirs.
All right.
That's the issue, because you're shifting risk onto in this case onto Mrs. Gerard by assigning title to her underwater.
All right, thank you, Mr. Shore. I've let you go on beyond your time, actually. So,
Thank you, Your Honor.
thank you for your comments and for yours as well. Excuse me, Mr. Look. I just called you Mr. Shore. That was wrong. Mr. Look and Mr. Shore, thank you for your comments this morning. The matter is under submission. You'll receive a written opinion within 90 days of
Thank you, Your
today's
Honor.
date. Thank you very much for coming.
Thank you.
I like your new courtroom, by the way. Last time I was here, it was not quite so nice.
It's had an upgrade, yes, thank you. All right, we will turn to the fourth and final matter on calendar, which is H050931, People Plaintiff and Respondent versus Pablo Pina, Defendant and Appellant. And we'll wait for people to appear remotely. Yes. Oh, they're audio only. That's right. I received a message about this. So for the benefit of my colleagues, each of the attorneys are appearing by audio only. So since that is the case, let me, before you even state your appearances, let me indicate the following. It can be a little frustrating for us to deal with audio because of the issue of wanting to ask questions. So if one of the justices here starts to speak, you need to stop. Otherwise, I need to start being involved. And there's background noise for somebody, so if you could adjust that, that would be helpful. Appearing for Mr. Pina, if you could state your appearance, counsel, and confirm your time estimate.
Aaron Schechter for the appellant, and 12 and 3, please.
Thank you. Thank you very much. And appearing for the people.
Ann Wathen, appearing for the people. I estimate 5 minutes, Your Honor.
Right, thank you very much. Let's turn back to Mr. Schechter, and you may proceed.
Thank you, and may it please the court. I wanted to first primarily address the issues memo that the court sent out last week. I guess there's 3 questions on the issues memo. The first question the court's wanting to know is whether the recent case of People versus Mayers is persuasive authority. I would respectfully submit that Mayers is. Sorry, is there a question?
No. Go ahead.
No. Okay. I would submit that Mayers is irrelevant to this case for exactly the same reasons as the Pickett case is irrelevant, as detailed in the reply brief. The procedural posture of Pickett and Mayers are exactly the same. And they're distinguishable from the instant case for exactly the same reasons. Pickett and Mayers are both guilty plea cases where the trial court relied on uncontroverted facts from the preliminary hearing, and they're both cases where there was no objection below to the use of this evidence. So in here, we don't have a guilty plea case where there's use of preliminary hearing testimony. We have a trial case where there's the use of trial testimony, and we have vehement objections below to this trial evidence. So I guess everything in the reply brief that we wrote about why Pickett's inapplicable, I would respectfully submit that Mayers is inapplicable for those same reasons. So either if the court agrees with my arguments as far as Pickett, they would equally apply to Mayers. I guess I don't want to rehash the arguments as far as Pickett. I think they're well laid out, but I'd be happy to, I guess I'll pause to see if there's any questions about issue number 1 before I move on to the rest.
No, and thank you for stopping and asking. I appreciate it, Mr. Schechter. You can go on. Thanks.
Oh, no problem. And then the other 2 issues in the memo are both about closing arguments, 2 and 3. I'll address those 2 together since they're quite a bit related. And the court can feel free to stop me if there's any questions. But so as far as the second question, which is the first closing argument question, is whether what should the court make of the defendant's trial counsel's concession and closing argument that it's been proved beyond a reasonable doubt that the defendant brandished the firearm, and as a result, the victim died. So I think the court's question sort of goes to the heart of the 1172.6 statute, that the spirit of that statute is, especially in these guilty plea cases, is that where there's proceedings based on the false premise of a law that's no longer valid, the defendant gets a fresh start. So defendant's lawyer, sorry, is there a question?
No.
I hear a little bit of background there. Okay. So the defendant's lawyer made certain closing arguments here under a previous legal framework that it isn't applicable under current law and shouldn't have been used against the defendant. And the defendant was obviously prosecuted at a time when the laws of murder were very different and malice could be imputed based on participation in an underlying felony. And for whatever reason, it appears that the defendant's lawyer made some sort of a strategic decision to argue for involuntary manslaughter in an effort to sort of get a compromise verdict out of the jury, instead thinking the jury wouldn't give an outright acquittal and he would save his client a life sentence and should go for involuntary manslaughter, apparently hoping the jury would split the baby. So, I mean, that apparent strategic decision was made by trial counsel under a totally different legal framework that just isn't applicable here.
Mr. Schechter, this is Justice Grover. So on that point, I do have a question for you. And I understand the argument that strategic decisions are made under the old law that might be made differently today. But looking at the current law and SB 1437, I mean, isn't it fair to say that the purpose of 1437 was to limit or eliminate accomplice liability, such that there appears in this case, strategy notwithstanding, to be a common denominator here as to Mr. Pena being the shooter, as opposed to a bystander or an accomplice?
I mean, Your Honor, that's certainly fair speculation, I would submit. I mean, I guess the point I would say is this is all speculation and we don't know. We're trying to read trial counsel's mind. We don't know. Maybe there was an argument that he could make that the defendant was an accomplice or I mean, the jury certainly found that he had a gun, and that doesn't necessarily mean that he used the gun and he was the actual shooter. But I mean, I just don't think we should be reading the tea leaves based on a strategy that was undertaken under a different law. I mean, I think it's reasonable speculation, but the standard for the getting to the evidentiary hearing at this prima facie stage is whether the record conclusively rules out any possibility that the defendant was ineligible for relief. And I just don't think it'd be appropriate to speculate on potential strategic decisions that the defendant may have made under the old law. And at this point, and I guess I would turn to the sort of part B, which is issue 3, which is the sort of the McCoy Supreme Court decision, and I would tie that in to the argument I'm making, saying that I mean, obviously the court's read McCoy, and it's obviously a Louisiana case. It's not 1172.6 case, but the principle of McCoy, I think, very well goes to bolster the argument I'm making here that it's even more fair. It's even more unfair to use this confession against sort of not confession. The defendant's counsel's attempt to make a confession and closing argument against the defendant when defendant's trial counsel obviously wasn't aware of the McCoy decision. It didn't exist, and he can't, like, I mean, the Supreme Court has since spoken saying that concession presumably made without the defendant's knowledge isn't fair to use against the defendant. So, I mean, I just don't think between the fundamental principle that we'd have to speculate on the trial counsel strategy, plus the bar is very low under 1172.6 in terms of conclusively refuting any chance of recovery. Plus, we have McCoy where it's like ineffective for a defendant's trial counsel to make a strategic decision to basically concede guilt during argument. So I think all of these three things together compel the need for a remand for issuance of an order to show cause. I mean, we're not granting we as in the court wouldn't be granting the defendant relief and throwing out the actual conviction. We're just getting to the next step and giving the defendant a evidentiary hearing where, the California Supreme Court under Lewis recognizes the bar is extremely low, or I think the bar is very low is the term they use.
Mr. Schechter,
yeah.
excuse me, this is Justice Lee. Leaving aside the legal framework under which counsel made the concession that they did in closing argument, quite apart from the legal framework, there's an evidentiary framework as well. And you've reviewed the evidentiary record that was before the trial court. And would you agree that there's nothing in that extensive record of the evidence at trial that raises any doubt as to whether Mr. Pena was the shooter?
Your Honor, I don't think Lewis allows you to look at the trial evidence. I think
would you agree that the trial evidence is part of the record of conviction?
I would disagree, Your Honor. I think
what's
Lewis
your best,
makes clear that
what's your best authority for leaving aside how it can be used? What's your best authority for the proposition that the trial evidence, as opposed to the arguments of counsel or the instructions, is not part of the record of conviction?
Your Honor, I would cite Lewis, and Lewis uses the phrase engaging in fact-finding involving the weighing of evidence. And so I want to sort of press you a little bit on the potential distinction between the use of the evidence, how a trial court reasons based upon that evidence, and whether that evidence is before the court on an 1172.6 at the prima facie stage as part of the record of conviction. Your Honor, I guess Lewis also says that the inquiry is at the prima facie stage is limited to readily ascertainable facts from the record rather than fact-finding involving the way of evidence. That's the more complete statement. So Lewis makes clear we look at like jury verdict, we look at the verdict forms, the instructions, that sort of there's a distinction between procedural history and fact-finding, and the trial evidence is a very different beast than the procedural history. And I think for a trial, what the real issue here is the trial court explicitly made a statement of what he thought the uncontroverted trial evidence revealed. And I don't think, when the trial court speaks about what the uncontroverted evidence reveals, it's making a determination, it's weighing evidence, it's doing exactly what Lewis says it can't do. And I think, aside, even if we throw out the closing argument, I think the real issue is that statement that by the trial court that the uncontroverted trial evidence revealed that only one person fired the gun while shooting. And I hope I answered the trial court's question. I think Lewis is the very strong authority that the trial record isn't allowed to be considered. There's some cases saying the preliminary hearing can be considered in these guilty plea cases, but as discussed in the briefs, Pickett's the main case that stands for that. Mayer's is the same case basically, and just there's no authority whatsoever to distinguish to apply these preliminary hearing and guilty plea cases to trial evidence. And what the trial court did here is weigh evidence, and it wasn't permitted to do so. And I guess unless the court has any more questions, I'd be curious to hear what the respondent has to say about the issues memo and reserve the rest of my time.
Well, let me press you a little bit on the point you just made. And,
no problem.
And that is about the, and let's assume, for the sake of this question, that the trial evidence is a part of the record of conviction here that can be considered at this stage. And so in terms of determining uncontroverted evidence, supporting or not supporting a particular point, isn't that another way of saying in certain contexts that you can pore over the trial evidence and not find a dispute on a particular point, as opposed to a trial court looking at the evidence, recognizing that there's a dispute, and nonetheless coming out with its own determination about how to interpret the evidence or a conclusion as to the dispute?
Your Honor, I would respectfully disagree. I think within the meaning of Lewis, that's all fact-finding involving the weighing of evidence, as Lewis says. I think the trial court has to conduct fact-finding to come to finding a fact that there's uncontroverted trial evidence. I don't think there's some higher beast where there's a way to make a determination of uncontroverted evidence without fact-finding. I think it's all fact-finding there. So that's what I would.
Even in I guess my question, to put it more simply, and I apologize for being convoluted previously, is if there is the absence of any contrary evidence, how does that involve weighing or fact-finding?
I mean, Your Honor, I still think that's fact-finding because a court could take a piece of evidence and say, oh, that's not contrary evidence, and somebody else could look at it and say, oh, that is contrary evidence. So it all comes down to fact-finding, Your Honor, and that's exactly what the Supreme Court meant, and that's why trial evidence in the first place isn't supposed to be part of this prima facie determination. This is why the defendant's entitled to an evidentiary hearing. It's all fact-finding. And when you boil it down, I would submit, and I mean, I think these are all fact-finding determinations that trial court's making. Whether, I mean, if you characterize it as not fact-finding respectfully, I would submit it's still all fact-finding.
Okay, I appreciate your commitment to your position. Thank you.
Thank you, Your Honor. And I guess if there's not further questions at this time, I feel like I'd like to hear from the respondents.
I think that makes all of us. At this point, let's hear from Ms. Wathen.
Thank you.
Thank you, Your Honor. Thank you. May it please the court. Well, our position is that the mayor's holding is persuasive authority in this case. In reaching that conclusion, the mayor, of course, was relying on the Lewis rule, which says if the record contains facts that refute the allegations in the petition, then the court is justified in making a credibility determination adverse to the petitioner. In this case, the trial court was looking at the trial record, and I don't think it matters that the defendant pleaded guilty in Mayers, because I think what Lewis is saying is any part of the record that contains facts refuting the allegations is acceptable to consider.
Well, Ms.
Wathen,
this is Justice Lee. If I could just press you on that a little bit. In Mayers, to the extent that there was a plea to voluntary manslaughter, you've got a judicial admission, not a concession by counsel. You've got a judicial admission by the defendant to an offense, the least adjudicated elements of which would seem to suggest actual killer status.
Yes, and I think here, though, it's not only the fact that the counsel conceded that he was the actual killer, but it's also the evidence in the trial record to show that he was the only one with the gun. He was the one that had the physical fight with Mendoza. He was shot in the forehead, and then right afterwards, appellant admits to Cruz and Oswald that he was sure that he had shot Mendoza. So there's no other evidence that anyone else was involved in that shooting.
Well,
and then,
so,
of course, this court.
Ms. Wathen, if I could just ask you this then. You know, Mr. Schechter's been asked about the weighing of evidence and the fact that there wasn't any contrary evidence that was admitted at trial. But at the 1172.6 stage, when we have a facially sufficient petition, we have the evidence in the petition, basically the petitioner's declaration. And are you not asking, I mean, was the trial court not essentially weighing the trial evidence against that declaration by the petitioner?
I don't think it was a weighing. I think he was just looking at the cold record of the trial record as the...
And finding the petition not credible.
Not finding any contrary evidence.
Because it was weighing the petition alleging that he couldn't have been convicted as an actual killer
I don't think it was a weighing
against the trial evidence.
I don't think it was a weighing. I think it was looking at just the trial record to see if it refuted any of the allegations in the petition. So I don't think that's considered a weighing. I think the trial record stands for itself as the evidence was presented in the trial court. And then, of course, part of that is, the jury determined, of course, it's not conclusive on that, but it determined beyond a reasonable doubt that appellant was the one that personally used a gun during the commission of that murder.
But
and
the personal use enhancement here, per the instructions, could have based merely upon brandishing the firearm as opposed to discharging the firearm. Would you agree with that?
Yes, but then I guess we're looking at the closing arguments where the prosecutors argued that appellant was the actual killer, and defense counsel has conceded that that's true.
Well, the defense counsel conceded that Mr. Pena brandished the firearm.
And as a result of that, the victim died. And then based on that,
Are we able to conclusively determine from the jury verdict whose finger was on the trigger?
I think not from the jury verdict, other than of course, the personal use of a gun. And then there's no other accomplices charged. Anything about accomplice was just to do with the corroboration. And it had nothing to do with, aiding and abetting theory here. So I think it's a combination of the trial evidence, the closing arguments, and then, of course, the finding of the personal use of a firearm during the commission of the murder. And then I think that McCoy doesn't prevent the court from relying on that defense counsel's concession, because in that case, it was clear from the defendant that he objected to his counsel conceding to his guilt to the 3 murders.
Does it matter then, Ms. Wathen, that on the 1172.6 petition, Mr. Pena is objecting to our consideration of that concession as having any evidentiary weight or having any conclusive legal effect?
I'm sorry, I don't think I understood the full question there. Sorry.
Well, I mean, you were saying that in McCoy there was an objection.
Yes. And then also a testimony by the defendant himself that he's denying his guilt and giving an alibi defense.
Are you suggesting that McCoy's validity turns upon whether there's actually affirmative contrary evidence from the defendant?
Well, I think the McCoy is saying that I think the issue there was that he wasn't able to make a fundamental choice about his own defense. So that's why these admissions were totally a structural error in that case. But I don't think we have that here, because there were no objections by appellant. Even before counsel made the admissions during closing arguments, he admitted appellant's guilt to the offense of involuntary manslaughter. When he was talking about the section, he was making his motion for the 118.1 motion and discussing the proposed instructions. And during that time, he stated that appellant had brandished the weapon and was guilty of involuntary manslaughter, but argued that offense was the only one that should stand and go before the jury. And at that time, appellant raised no objection to that argument. And in nowhere in the 1,300 pages record did I see any objection to admission of the guilt on the basis of involuntary manslaughter.
No, but
and
I mean,
of course he did not.
Excuse me, counsel, this is Justice Greenwood. I mean, realistically speaking, McCoy was a very unusual situation in which essentially you've got a capital defendant who's at probably the most important point of the capital case. Counsel concedes guilt and then decides to fight the penalty phase. I mean, that's a very different circumstance. And are you attempting to assert that a defendant in more conventional criminal case, the non-capital litigation, would be somehow standing up in the middle of trial and saying, I didn't say that. I don't authorize my lawyer to make that argument. I mean, I think that's a little unusual. Counsel speaks for the defendant in most instances, unless you have a Marsden hearing.
Right, and I think also though the section 1118.1 motion and the proposed instructions were not in front of the jury. So I mean, I think that's where I would expect if appellant was, you know, if there was any objection at all, it could have been, of course, not in front of the jury, but at that point when he was raising that motion, moving the court to just eliminate all the offenses except for the involuntary manslaughter. I think at that point, of course, counsel is representing him, but there's no jury where, you know, you're seeing what happened in McCoy, where it seemed to be much more verbal about it in front of the jury. But I don't think, I think when that was discussed, there was an opportunity there to object, and there's nothing in the record otherwise, even, you know, any other out of the presence of the jury discussions where appellant is just indicating that.
Ms. Wathen, can I change the subject a little bit and ask you, if we accept that the evidence submitted at trial is part of the record of conviction, where does consideration of that evidentiary record shade from deciding at the prima facie case, at the prima facie stage, what the actual jury necessarily found as a matter of law, into deciding what the evidence shows Mr. Pena actually did as a matter of fact?
Yes, I mean, are you asking me if
I'm asking you whether there's a distinction in your view, just to begin with. Or do you view this as being entirely the same thing?
I'm sorry, what's the distinction that you're asking about? I'm sorry, I must have lost it.
So on the one hand, at the prima facie stage, a trial court is entitled to consider what the jury necessarily found as a matter of law by virtue of its verdict in determining whether the petition should proceed to a D3 hearing. Let me finish my question.
Sure.
And I'm asking you how that differs, if at all, from a trial judge considering the trial evidence to determine what Mr. Pena actually did as a factual matter.
I think there is not a big distinction, because I considered the trial evidence and the trial record, the reporter's transcript, and all of it.
And then how does that, if to the extent that that's your view, and I appreciate your candor on that, how does that not distort what one otherwise understands the term prima facie to mean?
Well,
when we're talking about the sufficiency of a petition, prima facie.
Right. But I think when you look at Lewis, it says that we can look at any facts that are refuting the allegations in the petition. And I think that's where
facts?
Any facts that are refuting the allegations, if it's part of the record. And I would say that the trial record, reporter's transcripts, of course, verdicts and instructions and all that is part of the record. Any other questions?
No, there are apparently no other questions. I was just checking that myself. All right, so let's turn, thank you very much, counsel. And let's turn back to appellant's counsel for his final comments.
Thank you, Your Honor. Just briefly, I think there's been a lot of discussion about what weighing means and what uncontroverted means and whatnot. I think the big picture here is Lewis sets the bar very low for an evidentiary hearing under D3. Lewis recognizes that you're not by giving a D3 hearing, you're not giving the defendant relief necessarily. And I would ask this court to consider the big picture here, really, that, if it's so clear that the defendant's the actual killer, and then the D3 hearing would be very easy and the people could easily prove it up. But I mean, I think as a matter of procedure and fairness, the defendant met his burden by demonstrating a prima facie case, and I don't see the harm in this court remanding for an order to show cause and an evidentiary hearing, just given the procedural posture here. I think it's, I guess if the defendant's guilty as the actual killer, he's not getting any kind of relief in the end anyway, and Lewis recognizes that's the real issue, that the burden's low, and Lewis recognizes that a lot of defendants who are ultimately going to be guilty under either the old law or the new law are going to end up with D3 hearings that aren't going to go anywhere in the end, and that's what the legislature intended, and there's nothing wrong with that. So I would ask the court to reverse for an order to show cause and an evidentiary hearing. Unless the court has any more questions, I'm prepared to submit.
No, I don't believe there are any other questions. Counsel, thank you, both of you, for appearing by audio today. This matter is now under submission. You'll receive a written opinion within 90 days of today's date. And this being the final case on calendar, court is now adjourned. Thank you.